I'm attorney Susan Williams. I have a private practice in Summerville, South Carolina. I am a former state prosecutor, and the majority of my cases as a prosecutor were criminal domestic violence, whether it be on the magistrate level, the municipal level, or the state court level. Some general considerations when handling a domestic violence case would be to consider the victim and the defendant's weight and height disparities, the age of the victim versus the age of the defendant. These are factors that are important when evaluating a case. Also important is who, if anyone, was under the influence of what, whether it be a drug, an illegal drug, a prescription drug, or some type of alcohol or substance. And if someone is using, is that box checked on the police report? This is something that is important when you would be cross-examining the police. If someone was supposed to be on medication and they weren't on their meds, that would also be important. The emotional and physical condition of the victim and the defendant. For example, was one of them disabled in some way? And also, very important is, did the victim wish to press charges when the defendant was being arrested? And has that changed since the time that you have the case and even time to go to trial? Has the victim's position changed? And if so, why or why not? Also, who is the primary financial provider? If the defendant is the financial provider, the primary breadwinner in the residence, the state may say that that person has some type of control over the victim. That would be something you want to watch out for. Is if the victim is a stay-at-home mom or stay-at-home dad, are they doing so by choice? Does this person have the means to get out and have a job of their own, or are they bound at home and sort of controlled by the defendant? Is there a different language that the defendant or the victim speaks? And if so, was there a translator on the scene to adequately translate what was being said? This is also an issue where a victim can be isolated because she doesn't know people or he doesn't know people in the area. She doesn't know how to properly communicate. He doesn't have a driver's license. So these are all factors that would be brought up in the whether or not the defendant is controlling or isolating the victim. And also, is this an isolated event? Are these frequent flyers? Are these people that often call the police? Are the police familiar with these two folks? And even if they're not familiar with them together, are the police familiar with one or the other as a consistently being a defendant or consistently being a victim of domestic violence? Now, it's important to know when someone calls you the differences between domestic violence degrees versus domestic violence offenses. A degree is what is the severity of domestic violence as determined by statute, as opposed to an offense, which is how many times has the defendant been convicted in the last 10 years of domestic violence. And I've given an example on slide 6. Domestic violence third offense means that the defendant had 2 prior convictions for domestic violence related offense, either in this state or another state in the last 10 years. And then domestic violence third degree is laid out by the statute. So when someone calls me, they typically will say, I have a domestic violence third, and you would need to differentiate to figure out, does this person mean third offense or third degree? So just some more general considerations in a domestic violence case. What is the motive of the victim? When was this reported? Was the incident reported a week or the same day that this happened, or was it reported Is there a pending divorce action? Is this reported around the time that a hearing is coming up for a family court hearing, or someone's trying to set the defendant up to look like a bad dad or a bad husband? In South Carolina, as you may know, that one of the grounds for divorce is physical cruelty. So I have seen the motive of filing a domestic violence charge as trying to get a divorce based on physical cruelty, when in fact that may just be a trumped up charge. Blackmail. Does the victim need child support and the defendant won't pay it? Does the victim think that the defendant owes him or her money, or the defendant won't give them back their items? Does the defendant have a new girlfriend or a new wife and the victim just can't handle it? She's going crazy. She wants to be spiteful, or he wants to be spiteful, being jealous. So those are all what I consider blackmail reasons for the motives of a victim. Of course, the credibility of the victim is also extremely important. Does the victim have a history of lying, not just on police reports, but in their lives? Does the victim have any criminal convictions for crimes of dishonesty, whether it be false information to police, shoplifting, breach of trust, those types of crimes of dishonesty? And then the credibility of the victim, continuing on that, it goes with the motives of the victim. Want to look at, has the victim recanted, either with this case or an unrelated case, either with the same defendant or a different defendant? Does the victim have a history of recanting and just not having a good reputation for being a truthful person? Has the victim been fired from a job because of dishonesty or stealing? You can always check out a victim's social media accounts. You'd be surprised what you can find on someone's Facebook or Twitter or whatever there is out there about either the victim's character or photos or just ideas that are put up by the victim. I think that you can find some very interesting things that could be helpful for your case, and I would do this early on in the case before the victim realizes you're doing it and deletes it. Now let's talk about witnesses. Oftentimes, as you may know, there are not very many witnesses to domestic violence cases because this happens in the privacy of people's homes usually, but there are times when there are witnesses, and that makes defending the case somewhat harder, especially if the witness is someone who is not related at all to the parties, has no interest in reporting this. But if you look a little deeper, the credibility of the witnesses is very important. Is the witness someone who is related to the victim or to the defendant? And I don't mean, it could mean family related, but it could also mean, is the victim the landlord? Is it a tenant of the landlord? Is the defendant someone that is an ex of the defendant? Is it just really a random third party, someone who has no reason for bias, but then look for reasons for bias? It is a disgruntled relative who just never wanted their son or daughter to be married to this person, and they just never have liked him from the beginning. Does the witness have a criminal record that involves a crime of dishonesty, similar to the victim? When we went over this on the credibility of the victim, does the witness have a propensity to lie? Have they been fired at work for crimes of dishonesty or for lying or taking things? How long has the witness known the parties? If they just have never even met them, that makes the case stronger, I believe, somewhat for the state. And then finally, did the witness actually physically see anything? The witness can sometimes be someone, for example, that is a sibling of the victim, but that sibling lives in another state. They're not physically present when the event occurs, and that may skew what they are reporting to the police if the witness calls. Is the witness actually hearing anything that's going on? Those things are important to evaluate what kind of witness we have. And so now we're just getting into the nuts and bolts of the statute. Household members, it's absolutely necessary for the state to prove that there were the male and female that involved in this incident were household members. Notice that the statute only recognizes male and female. If they are same sex, same gender, then it would be considered some type of assault. It would not be, as the current law is, a domestic violence case. But assuming there are male and female, the victim and the defendant, they don't necessarily have to be living together. They can be not living together and married, which is kind of an odd situation, but I've certainly seen it. They may be not living together and they used to be married. They may have a child in common and they're not living together, or maybe they just used to live together. If they are currently living together, they can be living together and married. They can be living together and not married. They can used to be married and living together, which is another odd situation that I've certainly seen. Or they can be living together and have a child in common. So just be aware that household members, it goes beyond just the literal sense of what a household member is. They don't actually have to live in the same household. Now, living together, it's not actually defined by statute. So what I've done in my experience is I've taken in just looked at some factors to determine what would we look at to determine if to prove or disprove that someone's living together. Where's the mail delivered? What address does the victim and the defendant use on their driver's license? Is it the same address? Do they have different residences and they just stay over at one or the other's residence for a couple nights a week? Or is this like a one-night stand situation? The old school way would be what address is listed in the phone book. It's probably, I don't even know if people use phone books anymore, but it's, maybe what address is listed online. Where are the belongings kept of the victim, of the defendant? If there's only a few items at one or the other's residence, that would be a consideration. What belongings are there? Is it just a bag of clothes? Is it couches? Is it the victim's grandmother's hope chest? What is it that is actually there? Look at the amount of time, quote unquote, lived at the residence. If it's, like I said earlier, if it's just over the weekend, one weekend, they're not really living together. You could certainly make that argument. Whose name are the bills in, particularly the bills that are directly tied to the residence, like the utility bill. If the defendant, if the victim is living in the defendant's residence and the victim is paying the water bill, then that may be some evidence that he or she actually lives there. If they have a mortgage or a rental contract, whose name is it in? Is it just in the victim's name? Is it just in the defendant's name? Or is it in both of their names? And then also, living together, the language barrier comes in again. Was there a translator there to translate what living together means? And if so, did that person actually understand the term living together? Of course, married in South Carolina can mean legally married, like they had a ceremony or they went to the probate court and got a marriage license, or there's common law. So you would want to look at that part of married under the household members. Now, under the new, I call it the new domestic violence law, it actually is for cases where people were arrested after June 4th, 2015. I find the way the statute is written, believe it or not, I find it's easiest to read it and interpret it from the bottom up rather than starting from the beginning. So that's what I'm going to do in my presentation. I hope it helps you. It certainly has helped me understand it. The domestic violence, so we'll start out with the least serious of domestic violence offenses. That would be domestic violence third degree. It is in magistrate or municipal court. It carries up to 90 days, so it actually can end up in general sessions, and that is something that would be up to the solicitor to decide. It is can also carry a $1,000 to $2,500 fine. I haven't seen the fine imposed very much on my cases, but it is there. This person could be eligible for a pretrial intervention. We'll talk about that later if they're eligible, if they meet the other eligibility requirements. It's a misdemeanor. With all domestic violence convictions, the person loses the right to carry a gun under federal statute. And living in South Carolina, that can become important with hunting. That is a major factor. It has been a major factor in some of my cases. If the client is eligible for expungement, meets all the other elements for expungement, after domestic violence, it takes 5 years rather than 3, which is with misdemeanors other than domestic violence. So there is that 2-year additional time that you have to wait after a conviction. And so it ends up being a total of 5 years after the conviction. So now let's talk about just defining what domestic violence third degree is. Again, the victim and the defendant are male and female, they're household members. The defendant either physically harms the victim or threatens to physically harm the victim. And so just looking at that part, there doesn't have to be an actual injury. A threat to injury is part of this statute, and that's where so many people, clients that call in think, I didn't lay a hand on him or her, and I've ended up with this charge. The court will look at, would a reasonable person in the victim's shoes fear imminent peril? In other words, would it be conceivable for this to even actually happen? Would a reasonable person be in fear of imminent peril? So going on to domestic violence, second degree, moving on to that, it is a general sessions court offense. We're out of the municipal court and magistrate. There is no option. It is definitely in general sessions court. It carries up to 3 years in jail or $2,500 to $5,000 fine. Probation is an option. There is no mandatory minimum jail sentence. It is a misdemeanor. The person could be eligible for PTI, and of course they lose the right to carry a gun under federal statute. And I would get this to your client in writing before the plea, so that they understand the collateral consequences and you are off the hook. For if you verbally tell them this and they claim to not know it later, it's a very good idea to get them to acknowledge in writing that you have advised them that they cannot carry a gun. So let's look at the elements of domestic violence second degree. Basically, all the elements of domestic violence third degree that we just went over, and the victim was unconscious. He or she was disfigured, either temporarily or moderately. They can't use their arms, legs, toes, feet, or fingers. Their organs aren't temporarily working, and if the victim has to get some kind of general or local anesthesia because of the injuries. It could also mean the victim's bones are fractured or dislocated, that they have to have medical treatment more than one time, and the victim has to have more than just scratches or bruises, cuts, burns. It has to be something more than just those things. So also, we want to look at, in this particular type of crime, the defendant should have one domestic violence conviction on their criminal record within the past 10 years. It may not be called domestic violence in another state, but if it meets the statutory elements, then certainly it can be considered for a conviction. I have had to pull up statutes in other states to see if their elements are similar to South Carolina's, and to make an argument whether or not that would count as a prior conviction. If the defendant has violated a restraining order, a protective order, if the defendant knew or should have known the victim was pregnant, we'll get to that. If the defendant broke into a place where the victim was without permission, like if they were in the process of committing a burglary or robbery or some type of kidnapping. Remember, kidnapping doesn't mean taking kids. It just means holding someone against their will, and they don't have the ability to leave because of something the defendant is doing. And then this is the big one that keeps coming up over and over again with this new law, is that there's always some issue with the phone. The defendant blocks the victim's access to call, so that they can't call for help, like 911, EMS, or get some type of help. Well, let's look at the victim sought medical treatment, that language in the statute. Did the victim go to the hospital from the scene? And if he or she did they want to go? Were they coerced into it, or did they feel obligated because of law enforcement wanting them to do this or urging them to? Did the defendant have to seek medical treatment? There's your, if the defendant did, there's your argument right there to help you with your self-defense argument. Did the victim ever seek any medical care? Did the victim, if the victim didn't go by ambulance the day or the night of the crime, the alleged crime, did she follow up in the next day or so? And if so, how long did she wait? And by then, what were her injuries, if any? Who decided the victim was going to seek medical treatment? Was it the victim's mom, who's an overly protective person? Was it law enforcement? Was it a neighbor? I recently had a case where someone was of a different, did not speak English, and the small community of older ladies that knew this person were urging her to go to the hospital even though she didn't need medical assistance and really didn't want medical assistance. Now let's talk about the restraining order. Was the defendant even aware of the order? Is this order through the family court, or is it through the magistrate's court? When I say was he or she aware of it, did they get proper notice to go to the restraining order hearing? Do they have a copy of the order? Did they appear at the hearing? This is important, did the victim initiate contact with the defendant? For some reason, people get restraining orders against defendants and then they can't stop calling them. They change their mind about it, but keep in mind that the defendant is the person who is subject to the order, not the victim. So if the defendant responds, then that's bad for your client. If the victim continuously calls, then I would suggest your client keeping a log of that somehow, whether it be screenshots from their phone, email, text messages, or Snapchat, however it is that he or she's trying to communicate with the defendant after a restraining order has been issued. Is the restraining order even still valid? These things do expire, and if it's expired, then he or she is not violating a restraining order. What is the effective date of the restraining order? And is it issued from another state? And if so, look into getting a copy of that restraining order. Does it even cover the actions in South Carolina? It may be limited to the state where it was issued. I always try to get a copy of the restraining order so that you can see what is the defendant prohibited from doing. Has the defendant violated it during the time periods that it has been in effect? And I think it's important to get a copy of the restraining order. Now, I mentioned that the defendant was somewhere during the domestic violence that he wasn't really supposed to be at, or she wasn't supposed to be at. Is the defendant breaking into the marital home? I mean, obviously, if the couple's still married and somebody doesn't want one spouse doesn't want the other spouse there, then that's not burglary if they have reason to be there. Also, did the victim let the defendant into the residence voluntarily? If he or she let the defendant in and then didn't like what happened, then once that person got inside, then that's not a burglary. Does the defendant have reason to believe that he or she was allowed on the premises? Like they were there to pick up the kids for visitation, or some other reason why they believe that they were welcome there. And this has been something that has really been coming up a lot recently, is the access to the phone. When I've had law enforcement on the stand, I've asked them, did you know whether there was a landline at the residence? And most of the time they don't look, which is good for your client. That means that there could have been another line of some type of communication that the victim could have used, and if the law enforcement didn't look for it, then that puts some question into the jurors' minds as to whether that part of the statute, that element, is met. Also, I realize that landlines are sort of outdated, but it's worth a shot just asking to put some reasonable doubt into the jurors' minds. Also, with there being cell phones being so common, some of the kids have cell phones. There's probably the kids have one, the victim, the defendant, and then think outside the box. It doesn't necessarily just mean a phone. It can mean a computer, a laptop, or some other device that could have helped the victim communicate. It doesn't have to just mean phones. A lot of times you'll see that it's claimed that the defendant broke the victim's phone, and therefore she couldn't call for help. But if there are other avenues available, then I would recommend looking into those and just making sure that law enforcement did that. So now we've gone through domestic violence third and second. We're on to domestic violence first. The penalties, as you know, increase as the degrees increase. The defendant has committed a domestic violence third and has 2 or more domestic violence convictions within the past 10 years, or has caused some serious injury on the victim's body, serious injury as opposed to moderate injury, that the defendant could have caused some serious injury to the victim's body. Note that actual injury does not have to happen. So if the defendant was driving his car erratically and the victim was in the way of where the defendant was driving, that could have caused that victim some very serious injury or death even. But maybe the victim got out of the way in just the nick of time. But that is what that can mean by could have caused some serious injury. Did the defendant use a gun? Did the defendant violate a restraining order or a protective order? Did the defendant know or should have known the victim was pregnant? And this is another one that comes up a lot. A minor child saw or heard the event. And we'll get into the specifics of that later. Again, broke into a place where the victim was without permission. It goes back to the burglary, and whether the defendant thought that he or she had some type of reason that he would be allowed to be there. Then it's the same language about blocking the victim's access to a phone or 911, EMS, or to get help. And then let's talk about using a gun. Was a gun merely present in the residence? For example, if the defendant is one room of the residence and the victim is in another room and the gun never went into the room where the victim was, that's different than the defendant pointing a gun at the victim's head and causing fear of imminent peril. And a reasonable person in those circumstances would fear that. How was the gun used? I had a case where someone was in another room loading, getting ready to go hunting, and the gun, yes, a gun was involved, but it never was pointed at the person. The person was going hunting, and once the gun was mentioned, that sends some type of message to the police that this needs to be to a domestic violence first offense. Was it loaded? Did the gun actually even work? Was it an antique gun? Was it something that looked like a gun, but it actually wasn't? Was it ever presented to the victim? And there have been cases where the victim had his or her own gun. So did the victim ever have the gun in his or her possession during the incident? I would recommend asking law enforcement for fingerprints. The last case that I had, fingerprints weren't taken, but that's something to think about. Who actually held the gun? And then if a gun is involved, was it involved so as to frighten the victim? Was the defendant threatening suicide? Or was the defendant threatening the victim with a gun? And then also, was the gun ever even found or taken as evidence? I had a case where someone thought the defendant had a gun, and a gun was never recovered despite an extensive search. So those are some things to think about when using a gun. That part of the element of a statute comes about. Now let's talk about the minor child saw or heard the incident. Some considerations to take into account is how old is the minor child? If the minor child is 3 months old, obviously that's a different perception of a child who is 12 years old. Yes, there's a child physically present, but it's a different scenario. And then the next one's come along with that is, what did the child actually see? Was the child sleeping? Did the child actually ever see anything whatsoever? Was the child even aware that anything was happening? I mean, if the parents of the child or the mother and father of the child are outside and the child is inside watching TV and never hears anything, that's different than the child being in the living room and watching something very violent happen between the child's parents or step-parents or what, boyfriend and girlfriend. Where in the residence was the child? And this goes back to maybe the child's room is upstairs and the parents were downstairs or vice versa. And a lot of folks are concerned about whether or not they can get a child witness on the stand. And my answer to that is absolutely. I put child witnesses on the stand when I prosecuted criminal sexual conduct with minor cases. And it all really depends on the maturity of the child. But I would recommend to not be hesitant, to be open-minded about putting children on the stand. No one likes to do that, but if it's necessary and it's something that the judge will go along with, and if you don't ask for it, you don't get it. So I would encourage you to not hesitate, or at least look into calling a child witness to the stand at trial. Now, we can go over briefly criminal domestic violence of a high and aggravated nature. It is basically another felony. It basically is domestic violence third degree, and the victim is at risk of death, serious permanent disfigurement. There is a use of a deadly weapon. The victim knew or should have known the victim was pregnant. Minor child saw the incident, and the same other types of elements as before, that the defendant was in a place where the victim was without permission. Defendant blocks victim's access to a cell phone, etc. And it chokes, smothers, or causes the victim not to be able to breathe. Watch out for victims who lost consciousness or blacked out. Did they black out because of the actions of the defendant, or did they black out because they had too much alcohol to drink? There are different reasons for blackout seizures. So just make sure that you look at all of the circumstances surrounding it. Let's talk about victim at risk of death. It doesn't always mean that a defendant pointed a gun at the victim's head. And like I said, the earlier example about being in the car, possibly running over the victim. And then, you can look at some things like, what are the victim's existing health problems? Does the victim have seizures? And is the defendant doing things like withholding the victim's medications That would put a victim at risk of serious death, depending on the victim's actual health problems and how badly they need the medication. Did the victim fear risk or death? In other words, in the victim's mind subjectively, was he or she actually afraid that they were going to die? And this is one that is worth looking into as well. Knew or should have known the victim was pregnant. Some of the cases, how could the defendant have even known this? The female was playing games with the male. I had a baby, but I had a miscarriage, so the defendant thinks that there is no baby. Did the victim ever notify the defendant that she was pregnant? How would the person know unless he was told? Did the victim ever say there was a miscarriage? How far along was the victim in the pregnancy? Obviously, if the victim's 8 months along, it may be a little more obvious than if she's 3 weeks along. Had the victim had any symptoms of pregnancy that the defendant would be aware of? If they live together and the victim is having morning sickness in the mornings and the defendant has seen this, that's different than if the victim is living somewhere else and having morning sickness and the defendant has no idea that she's even pregnant. Some other stuff, like had the defendant been to doctor's appointments with the victim regarding the baby? Had they picked out stuff for the nursery? When people go their separate ways after the victim is pregnant, that's something you need to look at some of these considerations. And then let's talk about a deadly weapon. Deadly weapon can be anything that's used to cause death. It's not limited to a gun or a knife or any kind of traditional items. It can be a car. It can be a screwdriver, a hammer. Anything that could potentially, reasonably cause death, a baseball bat. It doesn't have to be something that you buy at a gun or knife store. Whatever it could be that could cause the victim death is something that could be a deadly weapon. And over the years, I've seen different things that people have aboard, anything that a person could use and could end up the victim dying. Probably one of the most important parts of this presentation is for us to look at the different defenses to domestic violence. The best and probably first consideration of defenses I use typically is self-defense. Was the defendant trying to restrain the victim from hitting the defendant? Is there any type of self-defense wounds on the defendant, such as the defendant put his hands up while the victim was trying to stab him, and so as a result, he has cuts on his hands? That would be a situation where there would be a lot of blood, and the crime scene looks pretty bad, but when you look into whose blood it is and how it got there, it's a lot different than what it appears. I've seen cases where victims have caused their own injuries. It sounds horrific, but it happens. Victim is so bent on getting some type of revenge or just making this person's life miserable that he or she injures herself. I've seen people burn themselves with curling irons. I've seen them put on makeup to appear bruised. But then on the other end of the spectrum, the victim doesn't mean to cause any injuries, and he or she could trip, or they could have been in a fight or some kind of argument with someone on a different occasion, and the injuries, they're old injuries. You can look at the type of bruise, the coloring of the bruise. Is it a yellowish color? That typically means it's an older bruise. Or is it a purplish, pink, looking like a fresh type of bruise? Those are some specific things to be looking for. And just because a person has an injury doesn't mean that the defendant caused it. That's just one thing that I would like for you to keep in mind. The victim's injuries, we went over this, that they were caused by someone other than the defendant. Like they got in a fight with another woman over a man. Some of the injuries, I've seen this, that have been caused from a defendant were that the victim consented. If this is the type of sex that they are a part of, then this is not a domestic violence situation. This is something that the victim consented to. And that is something that, the victim would have to say, I consented to this. The victim's injuries were involuntary. I have had cases that were very difficult to win as a prosecutor, where the victim had a seizure and had involuntary motions that caused injuries. Hopefully, it's not the victim's first seizure. If the victim has a history of seizures, I would recommend getting those records. If the victim does not understand English, there was no translator provided or even offered, it's important for a victim to understand, who speaks a different language, what the word prosecute, do you wish to prosecute, means. Does that person understand what is going on with someone being arrested and the repercussions of that? Some other defenses, as I mentioned earlier, is that the victim and the defendant were not household members. If the state can't prove that they live together, that's an element of domestic violence, and you may be able to win the case on that. If the incident did not occur within the jurisdiction of the sheriff's department or police department, there's that. And then also just look back at the motive of the victim and the credibility of the victim. Those are all great things to look at when evaluating your domestic violence case. Now, another thing to look at is who reported the alleged incident. Some good things that would be great for your case would be a nosy neighbor, a disgruntled landlord, a family member that's hated defendant since day one, someone who's not physically present at the incident location, someone who can't see or hear anything that's going on. It's just their interpretation from a different location of what's going on. There can be a lot of domestic violence situations where there's an exchange of children and the new spouse or the new girlfriend is there, and the ex is the one that's pressing charges, and you have to look at the motivations of that person. Is it because they can't take the fact that the father of their child has moved on with someone new, or the mother of their child, or did something actually happen? Again, a non-English speaking witness with no translator, or a non-English speaking victim with no translator. And then who else would have reported the alleged incident? If it's the current girlfriend or boyfriend of the victim and the defendant is the ex of the victim, that would be something to look into. Not good for the defendant's case. The number one reason, the police officer who witnessed the event firsthand. This would be maybe outside of a bar, and either an on-duty or off-duty police officer who's an officer of the court sees this and reports it. That's a lot different than something happening behind the closed doors of someone's residence with no witnesses. When you have a witness like a police officer, their credibility and their reason to report it just isn't, it's something that sometimes holds more credit and it just holds more weight than a regular witness. Is the credible, sober neighbor is also a very good one for the state and not so good for the defense, especially someone that has never met your client or the victim. They have absolutely no dog in this fight. They have no qualms with these people. They just saw something, thought it sounded bad, and wanted to protect the victim, so they called the police. If they're sober, that's a plus, because then they can give you an honest evaluation of the facts and as they saw it. An unbiased third-party stranger is another thing. Again, if you're in the outside the bar on a sidewalk and someone just happens to see something happen, they have no idea who the victim and the defendant are. They have no reason or any grudges against these people. They just think that it's really bad what they're seeing and thought they should report it to the police. Of course, you would want to follow up so that you could talk to that witness, and you would want the police to take down that witness's personal information, contact information, because they would be a material witness to the case. And if that person can't be found because you don't have the information or can't find it, that turns into something good for your case. If the incident was captured on video or audio recording, that's bad for your case. Like if it's at a bar or a restaurant and video is just continuously rolling and it just happens to get captured what the victim and the defendant, whatever's going on between them, if it's some kind of physical altercation and that ends up being used in trial, that's not a good situation for your case. Equally important is, when was the incident reported? Did someone call 911 during the incident? Or is it someone who's vindictive that calls weeks later? The timing of it is very important, because also as time goes by, if there are any injuries, the injuries that were there when it was actually happening may not be there later. They may actually look worse weeks later or days later, depending on how the person's skin tone is. And why in the world did they wait to report it? Is it because they were scared of the defendant? Is it because their divorce action is coming up? There are all different reasons. So I urge you to explore those. Now, also, where was the defendant when the police arrived? Just because the defendant isn't at the scene of the alleged crime doesn't mean that he or she fled because he's guilty or she's guilty. Was the person trying to get away from a crazy, dangerous, quote-unquote victim, or someone else at the residence or gathering where they were, someone that wanted to fight the defendant, just wanted to avoid confrontation? Did the defendant know that the police were being called? Maybe the defendant thought that he or she did nothing wrong, so there was no reason to stick around. They had no idea the police were being called. And had they known, they may have stayed there because they did nothing wrong, and maybe they would have liked to have given the police their side of the story. Of course, the state will claim it's because the defendant knew that he or she was guilty and that he wanted to avoid going to jail. But just be mindful that that will be a claim of the state, and have your ducks in a row for your ways to counter that. And then also, once the defendant learned that there was a warrant out for his or her arrest, did they voluntarily turn themselves in? That doesn't sound like the behavior of someone who is guilty. That sounds like the behavior of someone who would like to go to court and prove their innocence, as opposed to someone who found out there was a bench warrant, maybe got contact from the police, and just decided, I'm going to blow it off and not turn myself in, and they can find me when they find me. And that's a different situation, and those are factors that you need to bring up in a bond hearing or later on in the case. If the defendant didn't flee the scene, you can use that to your benefit. The defendant had nothing to hide. The defendant was not fleeing because he or she was guilty. Also, was the defendant cooperative with the police? And this is something that I think is important. Did the police take photos of the defendant or get statements from the defendant? I have so many cases where the defendant says, nobody even asked me for a statement. No one took any pictures of my injuries. They were just concerned about the victim's injuries. And that is something that you can use in your client's favor, because you can say, you know what, police didn't even give my client a way to explain his or her story. They had their mind made up from the beginning and they were going to arrest the defendant, and that's exactly what happened. And now we don't have the only side of the story that we have from this incident is the victim's, and that's how the police wanted it. Can get so much out of a 911 recording. Request it with your Rule 5 request and keep on bugging them until you get it. You can get what's called a CAD report, CAD report, that goes along with it. It's something that spells out, it's kind of like a written, there'd be some TIN codes involved. So you want to make sure that you understand the individual TIN codes. They vary from police departments. But you want to get that report. You want to get the recording if that's available. Sometimes you have to go the extra mile to get that. Turn in the CD to the police department to get your version of it, and listen to it. I listen to it and I write down notes. Who is the person who calls 911? Is it the victim? Because if it's not the victim, then you look at what is the reason for this other person, and that goes back to the credibility of the witnesses and the witnesses' motives. What can be heard in the background? I've had cases where victim calls and just sets the phone down and you can hear the entire domestic violence situation, and sometimes it ain't good. If you hear a gun being fired, it ain't good, but you want to make sure that you don't miss that. This is a piece of evidence that's very important that seems to be overlooked sometimes, especially by the state. So you want to make sure that you get that. It may be good, it may be bad. If a victim calls in and he or she is completely calm, doesn't seem like they're under any pain or stress, that's different than someone who's breathing hard. You can hear someone, dishes breaking in the background or whatever. That's different. So you want to be able to give your jury real time what it seemed like at the time this incident was occurring. Is the caller upset, hurt, or crying? Is the person's voice hoarse? That can mean a number of things, but the state can argue it's from choking or something happening to the victim's vocal cords. I mean, it could mean other things too, like they had some kind of sore throat or something, but just be aware of things like that. Is the speech slurred? Is the victim under the influence of something that is causing her or him to speak that way, but also the slurring his or her ability to know exactly what's going on, and maybe the facts aren't being reported exactly as they they're happening. It's just as they are being perceived. Is this the first time the police have ever been called by this person, called to this residence, or for these two individuals, whether they moved? And remember that the state must lay if the 911 recording is bad, the state has to lay a foundation to get this into evidence. I would recommend having the dispatcher at court. When I was on the prosecution side, I would try and do that, because it can be tricky getting those records authenticated. But if something that you can use, great. But keep in mind, laying the foundation, you may have to put the dispatcher under subpoena. Now, photographs, let's talk about those. They're very important. Again, they have to also, as you know, you have to lay a foundation for them to have them admitted to trial. This was a recurring problem when I was a prosecutor. I would get pictures of injuries and no face. It could be an arm and it could be anyone's arm. I mean, obviously, the state wants to portray that it's the victim's arm, but is there something on this photograph, if you don't have a picture of the victim's face or a full body snapshot, is there identifying scars or tattoos that we think, okay, yes, the victim can show this at trial and it matches up to the photograph? Are there photos of the victim? Probably there are, but of the defendant, that is something that is missed by the police sometimes, and I think it's important to see what is the defendant's. Do they have any injuries? Are the defendant's eyes bloodshot? Does he or she? What do they look like? Are their clothes ripped? Are there photos of the residents of the crime scene? If so, are things broken or out of place? If they are broken or out of place, when did this occur? Was it during the incident? Was it before that? If the door jamb is broken, we don't know when that happened unless we have further description from the victim or the defendant. If the items were taken into place, is there a proper chain of custody? If clothing was taken, if a knife was taken, do we have the proper chain of custody? Remember when you're presenting at trial to use clear and large photographs, blow them up. It's not that expensive, and it just makes a world of difference to jurors that are sitting from a distance. It helps if there's something that helps your case, really blow that picture up and use that in your closing argument as an exhibit. Who took the photos? Remember that the person taking the photographs doesn't have to be the person testifying. It's just someone needs to authenticate the photograph and be able to tell the court in laying the foundation, this is an accurate depiction of what happened, how the scene looked that particular day, and nothing seems to be substantially different. When were they taken? You got a victim with an injury with no date and no way of knowing the date. That's important. They could be old injuries. We don't know who actually caused those injuries. Have they been photoshopped? This day and age, things are pretty easy to Photoshop, and photoshopping injuries in is a horrendous idea, but people do it. It wasn't something that was available. It wasn't as prevalent when I was a prosecutor, but it certainly is something that it's very easy to do, and you don't have to be very sophisticated to figure out how to do it, and it can be detrimental to your client's future and to your client's case. And now I want to go over bond conditions. I get a lot of requests to modify the bond, especially folks that have kids. How are we going to communicate about our kids, if nothing else? If I can't have any contact with the victim, well, I'll just go through my mom or my sister. No, I tell my clients, don't take any chances. I've heard a very successful and prominent circuit court judge say, a defendant cannot breathe the same air as the victim. If the victim's in Walmart and the defendant's there, defendant's got to go. No text, Facebook, social media, smoke signals, whatever creative ways that people have to communicate, don't do it if there's no contact order. Encourage the defendant to keep a calendar of records if the victim keeps attempting to contact the victim, to contact the defendant. Because, again, the defendant's the one that's under the order. The victim keeps calling the defendant, then that's something that the court needs to know. You would file a motion to get the bond modified, and here's some suggestions. The victim and the defendant should not arrive in court together. That's a no-brainer. You think people don't notice, but they do. They should sit on opposite sides of the courtroom. Be aware that the defendant and the victim can be asked to be in separate courtrooms so that the victim doesn't feel like she or he is under the threat or watchful eye of the defendant, that their statements can be freely and voluntarily given. The state can claim the defendant is attempting to control the victim if the defendant continues to provide financial support for the victim, paying bills after the arrest. So just be mindful of that. The defendant should be prepared to be honest with the judge. You do not want your client lying to a judge. It will get him or her in way worse trouble. So just have a little powwow with your client about being honest. That will be much more appreciated than lying. And then just to be prepared, bring a proposed order for the judge to sign on the day of the hearing. You can tell the judge, look, I have an order here. It'd make things a lot easier to just go ahead and get it signed and clocked in with the clerk of court. We want to look at some considerations of how long has it been since the defendant was arrested. There have been no complaints of unwanted contact with the victim during that time. Has the defendant completed or enrolled any kind of counseling? If the victim wants contact and he is voluntarily requesting it, that's different than not being that way. Present evidence of the victim contacting the defendant, text, phone calls, screenshots, and be creative. Don't think that, just ask to allow contact pursuant to a family court order so that it's just not all or nothing. Or maybe after your client completes some substance abuse or some domestic violence classes, then can they have some type of visitation or come back to the court within 90 days with a certificate of completion. Try to be respectful to the judge of the judge's determination, but also be creative and think outside the box of how this could be resolved. Sentencing options, PTI, weakened time is possible. Probation, to terminate upon completion of anger management. Time served, so absolutely be prepared and know the exact number of days your client was detained. That way, a time served sentence will be easier for the judge to consider. If there's restitution due to the victim, ask for PTUP or probation terminated upon payment. And finally, the collateral consequences. The immigration status of your client. If they're not a citizen of the United States, they need to know what immigration consequences there would be. I have my clients sign something that say that they will, or that they contact an immigration attorney, that they are aware that they should, and that way I'm covered in writing that I went over this collateral consequence. Again, firearms are prohibited. This includes hunters. Talk to your client about expungement eligibility, and this is really just during the time they're on bond. They can't go near a women's shelter. I hope that this presentation has allowed you to learn more about domestic violence. If you have any questions, feel free to contact me. My information is on slide 2, and thank you for your attention.